Hello, all. Welcome to Thursday night. John Skiba here with the Consumer Warrior YouTube channel. Great to be with you once again on a Thursday evening. It means it's not only after 5 o'clock and almost time for me to go home. It's almost the end of the week. It's Thursday. We're about there. Friday is right around the corner, just tomorrow. So, hey, thank you for reaching out. Each and every Thursday night, if you're new here, we do a live stream on the Consumer Warrior YouTube channel where I talk about all things debt related and I take your questions. So if you have a question about getting out of debt, whether it's bankruptcy, debt collection, lawsuits, whatever it is, I can give you some of my thoughts on it, maybe point you in a different direction, give you some resources on how to deal with those debts. Introductions. My name is John Skiba. I'm an attorney in the state of Arizona where I help people through Chapter 7 and Chapter 13 bankruptcy cases. I also do a lot of work in defending debt collection lawsuits from particularly junk debt buyers like portfolio recovery, Midland Funding, LVNV, all those people out there. So if you're dealing with those kind of debt issues, wage garnishment, all that, let's talk about it. There's already a ton of questions in the chat section by some of the people who are strong supporters of the channel. But if you have a question, if you're watching on YouTube, put it in the chat section. If you're on Facebook or on X, go ahead and just put it in the comments. I'll put it up on the screen and give you my advice. I am a licensed attorney in the state of Arizona, not licensed anywhere else. I got to give you my disclaimer. That's what us attorneys do best, is disclaim. We get to do the fine print. And so I'm not licensed anywhere else. So don't take this as legal advice. If you need legal advice, you can talk to an attorney. And if you're in the state of Arizona and you want to talk with me, I will put my link here where you can actually set up a consultation. And the link that I'm putting in there is also good if you're not from Arizona. We'll connect you with an attorney in your particular state who can give you specific legal advice, not just some guy talking on YouTube. So before we jump in, though, I do want to thank Solo. They are a great sponsor of our weekly live stream. They're running a cool promotion right now where they're going to give up to $4,700 to help someone to get out of debt. I put a link there if you want to enter their giveaway. Click on that. That'll take you to the sign up page and give you some more information on that. But $4,700 can help you get out of this. And then you'll be done with it and can move on, get it in the rear view mirror. All right. With all that being said, let's go ahead and jump into the question. So for today, iMelter. I don't know if I'm saying that right. Is it one melter? I think it's iMelter. Said, hello, what would happen if you take a year to return a car that is in a lease after bankruptcy, Chapter 7 discharged? Okay, so we got a bankruptcy question. Good question here. So in the Chapter 7 bankruptcy, it's really designed to get rid of credit card debt, personal loans, medical bills. Those types of debts are discharged completely. They just go away. However, secured debts like car loans and home loans, those typically do not go away. If you want to keep your car, you got to keep making the payment. If you want to keep your house, you got to keep making the mortgage. Now, a lease is something that's a little bit different. A lease is not technically, you're not buying the car, you're kind of renting the car, you're leasing it. And so if you're going to lease the car, in the bankruptcy world, that's what we call an executory contract, where this contract where there's still something for you to be done as far as completing it. And so with the lease, what you can do is you can keep the lease, you can assume the lease is what the legalese is where you assume it. Or if you don't want it, you can reject it. So if you go through a Chapter 7 bankruptcy and you're like, hey, I don't want to keep this lease anymore, I'm going to reject it, that means you won't owe anything on it going forward. So the question here, though, is, okay, your case is discharged. Can you keep driving the vehicle? You should make arrangements to surrender the vehicle. The same is true if you're buying a car and in your bankruptcy you decide you're going to surrender it. You should work with your attorney to make arrangements to surrender the car back to the lender. Usually what they do is they'll have you come drop it off at a dealership or whatever their process is so that they can take the car and sell it, but you wouldn't be held liable for any balance on it going forward. But in this situation, it says if you didn't take the car back and you're still driving it, it's unusual because if you don't voluntarily take it back, what they'll do is they'll often come and repossess it in the middle of the night, kind of take it and take the vehicle back. The danger here in keeping the vehicle if they're not coming to pick it up, and I have seen situations, particularly if if the car is older, doesn't have a lot of value. Sometimes the lender's like, I'm not going to get it. It's not worth the time and the effort for us to go get it. And so you end up kind of in this limbo state. But in a lease, particularly if you're driving around, I mean, one, I hope you have insurance on it. You got to have insurance. Otherwise, you could cause yourself some problems. You're going to run into problems with the title on it if you were to try to buy the vehicle down the road, or you can't really sell it because you don't own it. So my recommendation, take the vehicle back, get into a new vehicle. People are surprised how easy it is to get into a new vehicle after a Chapter 7 bankruptcy. It'll be a lot less stressful, a lot less uncertainty in your life if you take it that way. All right, let's see what Evelyn has to say. Evelyn says, I lost my debt collector case today in district court. Sorry to hear that. I'm pro se, meaning that Evelyn is representing herself. The debt collector doesn't own the debt, among other things. Can I appeal and still win? It's not fair. Or bankruptcy, thank you. She goes on to say it's for a Discover credit card. She lives in New Mexico. All right, Evelyn, let me tell you a couple things. So, excuse me. If you're going to appeal, okay, so if you lost just today, they may have given you some information on how to appeal the case. There is usually a specific time frame you have to file what's called a notice of appeal, letting the trial court know you're going to appeal the ruling. Now, it can be like in Arizona where I practice, like in our justice court system, you only have 14 days. In the Superior Court system, you have 30 days. So it might be 20 in your jurisdiction. You need to find out because that deadline is set in stone. If you miss it, you lose all appeal rights. You need to find out when that is, what they require you to file in order to have the appeal taken place. Now, I've talked about appeals before on the channel. It's important to understand. So if your case went to trial and you lost at trial and you appeal it, you don't get a new trial. What the appellate court will typically do is they're going to look for what's called an abuse of discretion by the judge who did the trial. So the appellate judge will look at any rulings that were made, determine if they weighed the evidence properly. If you didn't make any objections to their evidence, those are often waived at that point. And so it's important to understand before you jump into an appeal as far as what the standard of review will be. Standard of review is important because if it actually goes to trial, then the appellate judge is going to look and say, and I've said this before, I've had appellate judges tell me, look, maybe I wouldn't have ruled that way if I were doing the trial, but that trial judge wasn't so far out of bounds that we're going to overturn the ruling. They were within their discretion. The only time they're going to overturn it is if they abuse their discretion. Now, if they got summary judgment granted against you, summary judgment is different. Summary judgments where they filed a motion for summary judgment, said, hey, judge, here is our evidence. Tell us if we win. If they grant that on appeal is reviewed, what's called de novo, which is a Latin term saying they're going to review it with fresh eyes. They're going to start as if they're the first judge to see it. That you may have a better chance of having turned over than if it actually went to trial. So kind of a long answer there, but hopefully that is somewhat helpful. All right. Calissimo, thank you. Real Tax Talk, thank you for being here again tonight. Said, Mrs. BPO that I spoke of last time has an incorrect amount from Capital One. There was a payment that was made in 2023 and then affirmed in March of this year. Can Capital One be sued? Be sued for misrepresentation of the amount owed under the FDCPA. Capital One is also reporting the wrong amount on credit reports, even though they sent confirmation from a validation letter to me personally showing a lower amount. Okay, good question. So first thing, this question here, can Capital One be sued under the FDCPA? Capital One can maybe be sued, but not under the FDCPA. So the FDCPA is the Fair Debt Collection Practices Act. Fair Debt Collection Practices Act is a federal statute, and it is the rules for debt collection. However, there's a couple little asterisks you got to understand about the FDCPA. One, it only applies to debt collectors. It does not apply to original creditors. So Capital One is an original creditor. They're the one you took the card out with. It's bizarre, but the FDCPA does not apply to the collection efforts of Capital One. Two, it's got to be for a personal expense. It can't be like a business debt. So you got to make sure if you're looking at potential FDCPA claims, and this is something 100% you need to talk to an attorney. There are FDCPA attorneys all over the country. You can click on that link. We can try to connect you with one who do a great job. I don't do a lot of FDCPA work. I've done enough. I've done a lot of training on it, but I just don't file a lot of those kind of cases. So you need to understand that Capital One, likely you do not have an FDCPA claim against them because the law doesn't apply to them. Now, you mentioned that they were reporting something incorrectly in the credit report. That's different. There's another federal statute that governs that called the Fair Credit Reporting Act, the FCRA. There may be an FCRA violation if they're not reporting accurately. Furnishers of information to the credit reporting agencies, they have to make sure that what they're providing is accurate. If you can show that they're intentionally or negligently not providing accurate information, you may have a claim. You also, again, there are attorneys that handle FCRA claims. You definitely need to talk to one of them to be able to help you to navigate that system. So, all right, Mike says, John, this week I learned that here in Cook County, Illinois, the courthouse, they don't have a transcribed records during the court proceedings or other hearings. Is this normal? How do they appeal cases? What you should ask, the days, I can say here in Arizona, the days of the court reporter sitting there typing away in the courtroom are pretty much gone. You actually have to request that happens. Specifically, you have to order that, have a live person there to actually transcribe trials or hearings. In Arizona, everything's digitally recorded. There is an audio recording, and then if you're going to appeal it, you have to get a copy of that audio and have it transcribed through a court reporter. I think that the days of the court reporter are almost over. AI has completely changed that, where it's very easy to make a very accurate record based upon the recording. So I would ask the court if they have an audio recording of that you can get a copy of. I would be shocked if they didn't have it. I mean, some jurisdictions, I think they require you to request it ahead of time that it be recorded, but almost everything's recorded. I mean, you see all these court TVs, there's usually even video recording of most things like trials. All right, let's see. I had a consultation with you recently. It was on the fence if I wanted to go through BK. Is a second consultation an option? Sure, give me a call. I'll put again my little link here. That will take you to my team and get you set up. I'd be happy to talk to you. Screw it, 9999. Give us a call. I'm happy to do a follow-up on there. All right, I wanted to jump into a couple questions from the channel that I thought were pretty good. This is from the comment section over there. This is in relation to debt collection lawsuits. And this person was talking about getting served with the summons and complaint. Said, what if the summons wasn't handed to you directly, but given to someone else to hand to you? So the process server comes by, they knock on the door, they say, hey, is John Skiba there? And it's my 16-year-old daughter. And she says, nope. And the process server says, here, can you give this to you, John? Give this to your dad. And then they walk away. Does that count? Is what John JMACC 6977 is asking. I can tell you in most jurisdictions, I believe that will count if a few conditions have been met. One, they have to serve you at your residence. So they have to serve you where you live, and they have to serve someone who typically resides with you. So it can't just be that you're having a dinner party and some friend answered it, or your teenagers are having friends over on a Friday night and they accepted it. They've usually got to reside with you. And the law says they must be of suitable age and discretion. What does that mean? Not a lot. Can a 5-year-old accept service? No. Can a 12-year-old? Maybe. I guess it depends on if they are of suitable age and discretion. If they're viewed as responsible. So if they bring it by your house and they don't hand it to you directly, but they hand it to a spouse, or they hand it to maybe an adult child, or maybe a child in their teens, then it's a situation where it's possible. It's possible that they could, that'll count. So you got to kind of look and see how they did it. Here's my general advice. When in doubt, assume the service was good and answer it. Because the problem that you have is if you ignore service, hoping that maybe it wasn't technically done correct, that's how you end up with default judgments. It's better to answer it, deal with this head on, than it is to try to avoid service, because at the end, you're going to end up with a default. So you got to be really careful about that. That would be my recommendation. If they brought it over and left it with somebody else at the house, just pretend that was accurate and go ahead and file an answer to it. All right, this person said, Consumer Warrior, can you do this? Okay, this was about compelling private arbitration. So many people, many credit cards have private arbitration clauses that allow you to take it out of the court system and deal with it through private arbitration. This one said, Consumer, can you do this, compel private arbitration in Arizona, where they have court-managed arbitration for cases under $50,000? Okay, so if you're not in Arizona, you can turn this off. This is not applicable to you. In Arizona Superior Court cases, Superior Court deals with anything over 10 grand. They have this process called compulsory arbitration. Now, this is different from private arbitration. Private arbitration is where companies like JAMS or AAA, the American Arbitration Association, these private companies, they hold arbitrations. You can pay them and they'll actually be the judge, kind of hire a judge type thing. Now, compulsory arbitration, and this is an Arizona specific thing, for cases under $50,000, where they're suing you for less than 50 grand, they actually require the parties to go through this compulsory arbitration process where they appoint an attorney to act as an arbitrator and hold kind of an informal trial. I always joke, this is kind of like jury duty for lawyers. If you're a member of the state bar, you can be chosen to act as an arbitrator in a case. And then, so it's not the judge in your case, but this attorney, regardless of their background, what area they practice in, they will act as an arbitrator and they'll have an informal arbitration hearing. Arbitration is kind of like I did one actually last Friday. It was done via Zoom. So, so the rules of evidence are more relaxed. In Arizona, they can just, instead of a witness, they can submit affidavits, something you can't do in trial. Or sometimes they're held like in a conference room, things like that. In Arizona, the compulsory arbitration process is non-binding, meaning if either party does not like it, they can ask the judge to just go ahead and set a trial date. So it does resolve a lot of suits. And so it's kind of a good view into how a third party, an independent third party, will view your case, whether it's good or bad. But it is non-binding. So to answer your question, you can still compel private arbitration. You don't have to stay in the court process, but it's different than compulsory arbitration, which you would have to participate in if you stayed in the case. So, all right. I think, Mike says that with the appeal and the recording, they said there's no audio. I don't know. I don't know what's going on in Cook County. There's maybe it's something you have to request. I always assumed, I just don't believe that they don't keep audio recordings. Just security purposes, that they keep audio recordings of everything. But maybe they don't. I don't know. So yeah, if there's no recording of it, I don't know how the court, maybe they could order a new trial or something like that. But you'd have to see, maybe sometimes in the documents that they send you, is that the reason that they send you all these documents in the fine print, it says, hey, if you want a recording, you got to request it in order for it to be valid. So. All right. I think we'll cut it a little early tonight, but I appreciate everybody checking in. Again, I'll put the link one more time. If you need an attorney, whether it's me or someone else in a different state, go ahead and click on that. Check out the giveaway with Solo. $4,700 they're going to give to someone to help deal with their debt issues and help you to move forward. Appreciate y'all checking in. If you haven't subscribed, please go ahead and subscribe to the channel. I really appreciate it. And we'll catch you next week.